Before we begin, please remember that this presentation is for informational purposes only and does not constitute legal advice. The information provided is not a substitute for professional legal counsel from a qualified attorney licensed in your state. Every case is different, and the details of your situation can significantly impact the outcome. We are not creating an attorney-client relationship through this video. 1 minute you're driving home, singing along to the radio. The next, it's a blur of screeching tires, shattering glass, and the violent jolt of impact. In the United States, a car accident resulting in injury happens every 14 seconds. And in that chaotic aftermath, while you're still trying to process what just happened, a clock starts ticking. It's a clock that most people don't even know exists. And every decision you make in the next 24 hours can either build the foundation for a successful recovery or completely sabotage it. Suddenly, your life is turned upside down. You're in pain. Your car is wrecked. The medical bills are already starting to pile up. And then your phone rings. It's a friendly voice on the other end, an insurance adjuster for the person who hit you. They sound so helpful. They just want to ask a few questions, get your side of the story, maybe offer you a quick check to make things right. It feels like a lifeline in a sea of confusion. But here's the terrifying truth. That friendly voice is not your friend. Their job is to save their company money, not to help you. That quick check they offer might be a tiny fraction of what you're actually owed for your medical bills, lost wages, and suffering. And that simple recorded statement you're about to give, it can and will be used against you to deny your claim and leave you with nothing. This is the fog of the personal injury world. It's a system designed by insurance companies and legal experts to be confusing and intimidating for the average person. But it doesn't have to be. Over the next 10 parts, we are going to pull back the curtain on the entire personal injury lawsuit process in the United States. We will give you a step-by-step, no-nonsense playbook, from the moment of impact to the final settlement check. This isn't just about legal theory. This is a practical guide to protect yourself, your family, and your future. By the end of this series, you won't just understand the process. You'll know exactly how to navigate it to ensure you get the justice and compensation you deserve. So let's go back to that ticking clock. It all starts with step 1, the immediate aftermath. This is your golden hour. The first 24 to 48 hours after the incident. Your actions here are absolutely critical. First, at the scene of the accident, your safety is paramount. If you are able, call 911 immediately. Getting police and medical personnel on site is non-negotiable. A police report is one of the most powerful pieces of initial evidence you can have. It's an official, third-party account of the incident. While you wait, if you are physically able, turn your smartphone into an evidence-gathering machine. Take pictures of everything. The damage to all vehicles from multiple angles, skid marks on the road, traffic signs, the weather conditions, and any visible injuries you have. Get a video walking around the entire scene. If there are witnesses, get their names and phone numbers. They might be strangers, but their testimony could be priceless later. And under no circumstances should you apologize or say, "I'm sorry." It's a natural human instinct, but in a legal context, it can be twisted into an admission of fault, even if you were just being polite. Simply exchange insurance and contact information as required by law, and say nothing else about who was at fault. Second, you must seek medical attention. I cannot stress this enough. Even if you feel fine or just a little sore, go to an urgent care center or the emergency room. Adrenaline is a powerful painkiller, and it can mask serious injuries like whiplash, concussions, or internal bleeding that may not become apparent for hours or even days. From a legal standpoint, failing to see a doctor right away creates what's called a gap in treatment. The insurance company will seize on this. Their argument will be, if you were really hurt, you would have gone to the doctor immediately. Since you waited, your injuries must not be that serious, or maybe you hurt yourself somewhere else after the accident. Don't give them that ammunition. Your health comes first, and documenting your injuries from day one is essential for your case. Finally, prepare for the inevitable phone call. The other driver's insurance company will contact you, and they will do it fast. The person on the other end is a trained professional whose entire job is to minimize the amount of money their company has to pay you. This is called controlling the claim. They will be incredibly friendly and empathetic. They will ask to record your conversation to get your statement for their file. You should politely but firmly decline to give a recorded statement. You are under no legal obligation to do so. Just say, "I'm not prepared to give a statement at this time. I will be in touch." Why? because they will ask you trick questions designed to get you to downplay your injuries or accidentally admit partial fault. So you're feeling okay, just a little sore? Did you see the other car at all before the impact? Anything you say can be taken out of context. The best response is no response, at least not yet. Securing the scene, getting immediate medical care, and deflecting that first insurance call are the 3 pillars of a strong start. You've stopped the bleeding, both literally and figuratively. You've preserved the evidence and protected your rights. But now you're facing a multi-billion-dollar insurance company that has an army of adjusters and lawyers on its side. You can't fight them alone. And that brings us to the single most important decision you will make in your entire case: how to choose the right person to fight for you. Because picking the wrong lawyer can be just as devastating as the accident itself. And in the next part, we're going to reveal the 3 critical questions you must ask any attorney before you hire them. Questions that the billboard lawyers hope you never learn. So, what are these 3 questions? They seem simple, but they cut through the noise, the flashy commercials, and the slick sales pitches. They are the keys to unlocking the truth about who will really be in your corner when the fight gets tough. The first question you must ask is, what percentage of your practice is dedicated exclusively to personal injury law? This isn't a rude question. It's a necessary one. Think of it this way: if you needed heart surgery, you wouldn't go to a general family doctor who does a bit of everything. You'd go to a cardiac surgeon, a specialist who has dedicated their entire career to mastering that one complex field. The law is no different. There are thousands of well-meaning attorneys out there who are general practitioners. They handle divorces on Monday, write a will on Tuesday, help with a real estate closing on Wednesday, and on Thursday they'll take on a car accident case. They might be a great lawyer, but they are not a personal injury lawyer. They are a tourist in a world where you need a seasoned guide. Let me tell you about a man named David. David was rear-ended by a delivery truck. His injuries were serious: a herniated disc in his neck that would require surgery. He hired a local lawyer his family had used for years. A good guy, very respected in town. When David asked him if he handled car accidents, the lawyer said, "Sure, we handle those all the time." What he didn't say was that he handled maybe 2 a year, and he'd never once taken one to trial. The truck company's insurance carrier offered a quick $50,000. To the general practice lawyer, who was used to dealing with smaller-scale legal disputes, this sounded like a reasonable number. He advised David to take it, telling him, "It's a good offer, and you can avoid the stress of a lawsuit." David, trusting his lawyer, agreed. A year later, David had the surgery. The medical bills alone were over $80,000. He lost 6 months of work. The $50,000 was gone in a flash, and he was left with a lifetime of pain and a mountain of debt. His lawyer, the good guy, didn't know how to properly value a long-term injury. He didn't know how to hire the right medical experts or an economist to project future lost wages. He didn't know the specific tactics that commercial trucking insurers use to minimize payouts. He was a tourist, and David paid the price for his vacation. A true personal injury specialist lives and breathes this world. They know the insurance adjusters by name. They know the defense attorneys on the other side of the table, their strengths, their weaknesses, their tactics. They know which orthopedic surgeons are respected by juries and which ones are seen as hired guns. This deep, specialized knowledge isn't something you can learn in a book. It's earned in the trenches, case after case, year after year. So, if the answer to question 1 isn't 90 to 100%, you walk away. This brings us to the second and perhaps most important question. How many cases like mine have you taken to a jury trial, and what were the results? Pay close attention to the wording here. Not how many cases they've handled, not how many cases they've settled, how many they have personally argued in front of a jury. This is the question that separates the settlers from the trial lawyers. And here is a secret the insurance industry does not want you to know. They keep a scorecard. Every major insurance company has a database on plaintiffs' attorneys. They know who will file a lawsuit but then get scared and accept a lowball offer on the courthouse steps. They know who has never actually picked a jury, and they know who the warriors are. They know which lawyers will spend the money, hire the experts, and are fully prepared and willing to go to trial to get a fair result for their client. The lawyer's reputation is one of the single biggest factors in the value of your case. Imagine 2 people, Sarah and Tom, with identical injuries from identical accidents. Sarah hires a settlement mill firm, one of those places you see on every billboard. Their business model is volume. They sign up thousands of clients and their goal is to settle cases as quickly and cheaply as possible. The insurance company knows this. They offer Sarah's lawyer a low, but not completely insulting amount. The firm pressures Sarah to take it because for them, a small quick profit multiplied by 1,000 cases is good business. Now look at Tom. Tom hires a trial lawyer. A lawyer with a proven track record of taking cases to verdict and winning. The insurance company looks at the file and sees that lawyer's name. Their entire calculation changes. The algorithm they use to value the claim spits out a different number. They know a lowball offer will be rejected instantly. They know this lawyer isn't bluffing when he says, "We'll see you in court." The threat is credible. As a result, the pre-trial settlement offers to Tom are significantly higher than the ones made to Sarah. Tom may never even have to go to trial, but he gets the benefit of his lawyer's reputation for being willing to go all the way. You want the warrior. You want the lawyer that the insurance company fears, not the one they have on speed dial for a quick and cheap deal. If a lawyer gets defensive or hems and haws, or can't give you specific examples of their trial victories, that's your answer. They are a settler, not a fighter. And that leads directly to our third and final critical question. If I hire your firm, who will actually be handling my case day to day and making the strategic decisions? This is the anti-bait and switch question. It's designed to unmask the reality behind the marketing. You see the senior partner on TV. He's the face of the firm. He's confident, experienced, and reassuring. You go in for your free consultation and you meet him. You're impressed. You sign the paperwork, and then you never see him again. Your case is handed off to a junior associate who is fresh out of law school, or maybe even a paralegal or case manager who is juggling 200 other files. When you call with a question, you get a different person every time. You feel like a number, a cog in a giant machine. This is the reality of the high-volume billboard lawyer firms. Their model is based on efficiency and volume, not personal attention and maximum value. The person you hire should be the person who is the lead strategist on your case. Of course, they will have a team, paralegals, investigators, junior attorneys. That's a sign of a well-run practice. But the key decisions when to file suit, what experts to hire, when to negotiate, and for how much, should be made by the experienced attorney you hired. So you ask them directly, will you be my primary point of contact? Will you be the one taking the lead in depositions? Will you be the one arguing my case in court if it goes to trial? A great lawyer will have a clear, direct answer. They'll say, I will be the lead attorney on your case. My paralegal, Jane, will assist with scheduling and document collection, and my associate, Mike, may handle some initial hearings, but I will be in charge of all strategy. I will be at every key event, and I will be the one at your side at trial. You can call my cell phone anytime you have a serious concern. A lawyer from a settlement mill will give you a vague answer. Well, we have a team approach here. Our case managers are excellent and will be your day-to-day contact. Mr. Bigshot oversees all the cases. That's code for you will never speak to the person whose name is on the door. These three questions, the specialist question, the trial warrior question, and the face versus the factory question, are your shield. They protect you from the predators and the pretenders. Answering them correctly is the single most important decision you will make, and it sets the stage for everything that follows. Once you've used this framework to select your champion, your partner in this fight, the real work begins. The clock is ticking, and the first move isn't a letter or a phone call. It's a race against time. In the next part, we will pull back the curtain on the critical first 48 hours after you hire your attorney. The frantic behind-the-scenes investigation to uncover and preserve the evidence that the insurance company is praying will disappear forever. The moment the ink dries on your attorney-client agreement, a silent alarm goes off. Not for you, but for the insurance company on the other side. They know the game has changed. While you feel a sense of relief, a sense of having handed your burden to a professional, your new legal team explodes into a flurry of calculated, frantic activity. The clock is ticking, and the next 48 hours are a sprint to seize control of a narrative that is already threatening to slip away. The very first action, often taken within minutes of you signing that paper, isn't a phone call or a visit to the crash scene. It's the firing of a legal missile, the spoliation letter. This isn't just a letter. It's a non-negotiable legal demand sent directly to the defendant and their insurance carrier. The language is cold, formal, and backed by the full force of the law. It says, in no uncertain terms, you are now on notice. Preserve everything. If you delete, destroy, alter, or accidentally lose a single piece of evidence related to this incident, we will bring the wrath of the court down upon you for spoliation of evidence. What evidence are we talking about? In a commercial trucking case, it's the driver's logbooks, the dispatch records, the truck's maintenance history, the driver's entire employment file, their drug and alcohol test results. In a slip and fall at a big box store, it's the surveillance footage, the sweeping and inspection logs, the internal incident reports, and the employee schedules. In a standard car crash, it's the vehicle itself. The letter explicitly forbids them from repairing the car, because the crushed metal, the broken glass, the bent frame, that is a story written in steel, and your expert needs to be the one to read it. Without this letter, that crucial evidence could be gone in a day. A trucking company could misplace a damning logbook. A store surveillance video, which is often on a 24-hour loop, could be overwritten. The other driver's car could be whisked away to a salvage yard and crushed into a cube of metal. Its secrets lost forever. The spoliation letter is the legal shield that freezes the battlefield exactly as it was at the moment of impact. While that legal demand is flying across the internet, someone else is already in their car, heading out to the scene. This is your law firm's investigator. These are not lawyers. They are often former police detectives, seasoned professionals who have spent decades reading the subtle language of chaos. While you're at home, nursing your injuries and trying to process what happened, your investigator is standing on the piece of asphalt where your life changed. They aren't just taking pictures. They are hunting. They are walking the path of the collision, looking for the things a police officer at the scene, who has 10 other calls to get to, might have missed. They see the faint, arcing skid mark that shows not just braking, but a swerve. They find the deep gouge in the pavement where a car's frame dug in after a tire blew. They discover a tiny fragment of a taillight 100 feet from the main wreckage, a silent testament to the true violence of the impact. They are looking up, documenting the position of traffic lights, the presence of stop signs partially obscured by overgrown tree branches. They are knocking on the doors of nearby houses and businesses. Did you see anything? Does your doorbell camera or security system happen to point toward the intersection? Often, the case-breaking piece of evidence isn't in a police report. It's on a hard drive in a back office of a gas station a block away. And in complex cases, the investigator is just the beginning. Your attorney is already on the phone, retaining an accident reconstructionist. If the investigator is a detective, the reconstructionist is a physicist with a badge. This is the expert who will take the investigator's photos, the police report's measurements, and the vehicle damage estimates, and plug them into sophisticated software that can recreate the entire event in a 3D animation. They use principles of physics, conservation of momentum, friction coefficients, crush analysis, to answer the questions that decide cases. How fast was the other car really going? Not what the driver said, but what the physics prove. At what angle was the point of impact? Was the other driver accelerating or braking through the collision? This is the science that dismantles the other driver's story, piece by piece. But the most powerful witness is often one that can't speak. It's the ghost in the machine. Almost every modern car has an event data recorder, or EDR. It's the vehicle's black box. In the 5 seconds leading up to a crash, it records a stream of unbelievable data. Vehicle speed, throttle position, brake application, steering wheel angle, seatbelt status. Your attorney's team moves immediately to download this data before the car is destroyed. This isn't a suggestion, it's a race. This data is the unbiased, unblinking truth. It can prove the other driver never even touched the brakes. It can show they were accelerating through the stop sign. It is often the single most important piece of evidence in the entire case. Simultaneously, a parallel investigation is happening. The hunt for the human element. Your legal team is trying to identify and contact every potential witness. Why the rush? Because a memory is not a recording. It is a reconstruction. And the first person who talks to a witness often shapes how that memory gets reconstructed. Your team wants to get their version of events, in their own words, before the insurance company's adjuster calls them. They want a signed, sworn statement locking in their testimony while it's fresh, before the passage of time and the influence of others can warp it. Now, you have to understand this is not happening in a vacuum. For every single move your team makes, the insurance company has a countermove. They are not waiting to see what you do. Their own rapid response team is already in motion. The moment their insured driver reported the crash, their machine whirred to life. Their adjuster is already trying to call you, hoping to get a recorded statement before you have legal representation. They sound friendly, concerned. We just want to get your side of the story. What they're really doing is conducting a strategic interrogation, looking for any admission, any inconsistency, any small detail they can use to deny your claim later. They are running your name through social media databases. That picture you posted on Facebook of you at a friend's barbecue a week after the crash? The one where you forced a smile for the camera because you were tired of feeling miserable? To you, it's a moment of trying to feel normal. To their lawyer, it's Exhibit A, which they will blow up on a giant screen in front of a jury to argue that you're not really hurt. They are moving just as fast as your team, but with an opposite goal. Not to uncover the truth, but to create an alternative narrative of doubt. They want to find evidence that you were partially at fault, that your injuries aren't that severe, that you're exaggerating for financial gain. So, within those first 48 hours, the entire battlefield is mapped and the primary battles are fought. The physical evidence from the scene is photographed, measured, and preserved. The digital ghosts from the vehicles are summoned and secured. The legal demands to prevent the destruction of corporate or private records have been delivered. The key witnesses have been contacted. The battle lines are drawn. Your legal team has worked tirelessly to lock down the how of the accident, to build an undeniable foundation of facts that will be impossible for the insurance company to tear down. But this is only half the story. The objective, factual part of the case is being built, but the other, more personal half is just beginning. Because while your lawyers are proving what happened to your car, you are starting the long, painful journey of proving what happened to your body and your life. And that journey begins with your medical treatment, a process that the insurance company will scrutinize, challenge, and try to tear apart at every single turn. Your every move, every decision from the moment you leave the accident scene is being watched. Not by some shadowy figure, but by an insurance adjuster sitting in a cubicle hundreds of miles away, whose entire job is to find a reason, any reason, to pay you as little as possible. And their first and most powerful weapon against you is your own medical journey. Think of your medical treatment not just as a path to recovery, but as the evidence-gathering phase of a major investigation. Every doctor's visit, every physical therapy session, every prescription filled. These are the building blocks of your case. And if any of those blocks are missing, cracked, or out of place, the entire structure can come crashing down. The insurance adjuster has a playbook, and the first chapter is called Gaps in Treatment. Let's say you're in a car wreck. You're shaken up, your neck is sore, but the adrenaline is pumping. You feel like you can tough it out. You go home. A day passes. 2 days. The adrenaline wears off, but the deep, aching pain sets in. It's now screaming at you. So, 3 days after the crash, you finally go to an urgent care clinic. To you, this makes perfect sense. You waited to see how you felt. But to the insurance adjuster, that 3-day gap is a goldmine. Their argument is simple and brutally effective. If you were really hurt, you would have gone to the doctor immediately. The fact that you waited 3 days proves the accident wasn't that serious. Something else must have happened in those 3 days to cause your injury. Or maybe you're just exaggerating for a payday. It's cynical. It's infuriating. And it works. That's why the single most important thing you can do after an accident, if you feel even a hint of pain or discomfort, is to get checked out. Immediately. Go to the emergency room. Go to an urgent care. Go to your primary care physician. Create a medical record that starts on the day of the incident. It establishes a clear, unbroken line connecting the event to the injury. Without that line, the defense will draw their own, and it will lead anywhere but to their client's responsibility. The second chapter in their playbook is called Failure to Mitigate. This is a legal concept that sounds complicated, but it's dangerously simple. It means you have a duty to try and get better. You have to take reasonable steps to heal. If you don't, the insurance company will argue that you are partially to blame for your own ongoing pain. Let's go back to our example. Your doctor diagnoses you with a significant whiplash injury and prescribes 12 sessions of physical therapy, twice a week for 6 weeks. You go to the first 5 sessions. You're starting to feel a little better. Life gets in the way. Work is busy. It's a hassle to get to the appointments, so you skip a few. Then you stop going altogether. You figure you've done enough. In a deposition, the insurance company's lawyer will pull out your physical therapy records. It says here the doctor prescribed 12 sessions, is that correct? You say yes. And it says here you only attended 5 of them. Is that also correct? Yes. So you chose not to follow your doctor's orders, didn't you? You chose to stop the very treatment that was supposed to make you better. How can you now ask my client to pay for pain that you could have prevented if you had simply followed your own doctor's advice? In that moment, they weaponize your recovery against you. They turn your personal decision into a legal defense. They will argue to a jury that they shouldn't have to pay for the last 30% of your pain because you failed to do the work to heal it. Every missed appointment, every unfilled prescription, every piece of medical advice you ignore becomes another brick they can use to wall off their money from you. So you have to go. You have to be the perfect patient. You have to build a medical narrative that is consistent, diligent, and unimpeachable. This narrative usually starts in the ER, which documents the immediate trauma. Then it flows to your primary care physician, who acts as the quarterback, directing you to the specialists you need. And those specialists are key. If you have back and neck pain, you'll likely see an orthopedist. If you're having headaches, dizziness, or nerve pain shooting down your arm, that's a neurologist. These specialists have the diagnostic tools, the MRIs, the CT scans, the EMGs, to look beneath the surface and identify the specific objective injuries. An MRI showing a herniated disc in your neck is infinitely more powerful than you simply saying, "My neck hurts." One is a subjective complaint, the other is a photograph of the damage. Then comes the active treatment. This is your physical therapy, your chiropractic care, your pain management injections. This phase is critical because it tells the story of your effort. It shows a jury month after month that you were working hard to get your life back. The records from these providers don't just show up as billing codes. They contain detailed notes about your pain levels, your struggles with daily activities, your progress, and your setbacks. It's a diary of your suffering, written by medical professionals. This entire process, from the ER to the specialist to the therapist, creates a mountain of paper, a mountain of evidence. Each page is a testament to what you've been through. But just as you're building your mountain, the insurance company is planning an earthquake to level it. This earthquake has a name: the Independent Medical Examination, or IME. The name itself is a masterpiece of deception. Independent. It sounds fair, doesn't it? It sounds objective. It is anything but. The IME is a medical examination that you are forced to attend, conducted by a doctor who has been handpicked and paid for by the insurance company. Let's be very clear about the economics of this. These IME doctors are not chosen for their medical brilliance or their compassion. They are chosen because they have a reputation for writing reports that favor the insurance companies that feed them a steady stream of business. Some of these doctors make hundreds of thousands, even millions of dollars a year performing these exams. They know exactly what the adjuster wants to hear. You'll walk into an office, often after waiting for hours. The doctor might spend 10, maybe 15 minutes with you. They'll ask you a few questions, have you bend and twist, tap your knee with a reflex hammer. The entire exam can feel rushed, impersonal, and dismissive. You leave feeling like you weren't truly heard. And then, a few weeks later, their report lands. It's a bombshell. The report might say that your injuries are completely resolved, or that your pain is from pre-existing arthritis that has nothing to do with the accident. Or the most common finding, that you are exaggerating your symptoms and are perfectly capable of returning to your life without any restrictions. This report is the insurance company's trump card. Your doctor, who has treated you for 6 months, says you have a permanent injury. Their doctor, who saw you for 10 minutes, says you're fine. Who does a jury believe? The insurance company is betting they can create enough doubt, enough confusion, to drastically reduce the value of your case, or eliminate it entirely. Navigating this medical maze is the foundation of your entire claim. You have to be diligent, you have to be consistent, and you have to understand that you are not just a patient trying to get better. You are a plaintiff building a case. Every step you take is being judged. Every decision is being scrutinized. Because all of this treatment, all of this effort, is leading to a single critical moment in your case. The moment your doctors say there is nothing more they can do for you. The moment you reach what the law calls maximum medical improvement. And it's at that point, when the physical healing stops, that the financial battle truly begins. And the first shot fired in that battle isn't a lawsuit. It's not a courtroom showdown. It's a document. A meticulously crafted, evidence-packed story of your life, distilled into a single, powerful package. But before that package can be sent, your legal team transforms from advisors into archivists. They embark on a mission to gather every single shred of paper that tells the story of your injury and its aftermath. This is the assembly phase. Think of it like a general preparing his forces before an assault. Your lawyer will request, subpoena, and organize a mountain of documentation. Every single medical record, from the initial ER report to the final physical therapy session. Every bill, every prescription receipt, every copay. They'll get the police report, witness statements, and any photos or videos of the accident scene. They'll gather your employment records to prove your lost wages, and your past tax returns to establish your earning capacity. If your case is complex, they'll bring in the experts. accident reconstructionists who can digitally recreate the crash to prove fault, medical experts who can write detailed reports about the long-term consequences of your injuries, economists and vocational experts who can calculate down to the dollar how this one moment of negligence has impacted your ability to earn a living for the next 10, 20, or 30 years. Each document is a soldier. Each expert report is a piece of heavy artillery. Your lawyer is building an undeniable fortress of facts, leaving no flank exposed, no claim unsubstantiated, because they know who they're about to go up against. Once this fortress of evidence is built, the next step begins: calculating the damages. This is where your lawyer translates your pain, your loss, and your suffering into the only language the insurance company truly understands: money. The law divides damages into two main categories. First, you have what are called special damages, or economic damages. These are the black and white, easy to calculate numbers. They are the tangible losses that come with a receipt. This includes every dollar you've spent on medical care so far. It includes the wages you lost while you were unable to work. It includes the cost of repairing or replacing your car, or any other property that was damaged. It even includes smaller out-of-pocket expenses, like the mileage for driving to doctor's appointments or the cost of hiring help for household chores you could no longer do. But the real value of a great lawyer comes in calculating the future special damages. It's not just about the bills you've already paid. It's about the bills that haven't arrived yet. If your doctor says you'll need another surgery in 5 years, the cost of that surgery is included. If you're going to need physical therapy twice a week for the rest of your life, the cost of every single one of those future sessions is calculated and included. If you have to take medication every day, the cost of a lifetime supply of that medication is part of the calculation. And what about your lost income? It's not just the paychecks you missed while you were in the hospital. What if you were a construction worker who can no longer lift more than 20 pounds? What if you were a surgeon whose hands now have a permanent tremor? Your lawyer, working with those economic experts, will calculate your loss of future earning capacity. They will project what you would have earned over the remainder of your career and subtract what you are now capable of earning. That difference, which can easily be hundreds of thousands or even millions of dollars, is a core component of your damages. But we all know that the true cost of an injury goes far beyond the medical bills and the lost wages. And that brings us to the second category: general damages, or non-economic damages. This is the gray area. This is where your lawyer must put a price on the priceless. How do you quantify pain? How do you bill for suffering? This is the most human part of the law. General damages include pain and suffering, which is the physical pain you've endured and will continue to endure. The searing agony of the initial injury, the dull, chronic ache that is now your constant companion. The headaches, the nerve damage, the sleepless nights spent staring at the ceiling because you can't find a comfortable position. It includes emotional distress, the anxiety you now feel when you get behind the wheel of a car, the depression that sets in when you realize you can't do the things you used to love, the post-traumatic stress that causes flashbacks and nightmares, forcing you to relive the worst moment of your life over and over again. It includes loss of enjoyment of life. This is about the theft of your hobbies, your passions. You used to love hiking, but now your knee can't handle the incline. You were the star of your local bowling league, but now you can't lift the ball. You loved gardening, but you can no longer kneel down to tend to your plants. These aren't just activities. They were part of your identity, and they were taken from you. In some cases, it can also include loss of consortium. This is a claim, typically brought by a spouse, for the loss of companionship, affection, and intimacy that results from the other spouse's injury. It acknowledges that when one person is seriously injured, the entire relationship suffers. Calculating these general damages is more of an art than a science. There's no simple formula. Lawyers and insurance companies often use a multiplier method, where they take the total special damages, the hard economic numbers, and multiply them by a number, usually between 1.5 and 5, depending on the severity and permanence of the injury. A minor sprain might be a 1.5 multiplier. A catastrophic injury resulting in paralysis could be a 5 or even higher. With all the evidence gathered and every last dollar of damages calculated, your lawyer now drafts the document that officially starts the fight. This is the demand letter. And a good demand letter isn't just a letter. It's a legal masterpiece. It's a closing argument on paper. It typically runs 10, 20, even 30 pages long, and it tells your story in excruciatingly compelling detail. It begins by laying out the facts of the case in a clear, narrative fashion. explaining exactly what happened and why their insured client is 100% at fault. It attaches the key evidence, the police report, a crucial witness statement, a damning photograph. Then it moves to liability, citing the specific laws and statutes the other party violated. It systematically dismantles any potential defense they might try to use, like arguing you were partially at fault. Next comes the most powerful section, the damages. It details your injuries, referencing the attached medical records. It tells the story of your treatment, your surgeries, your painful rehabilitation. It explains in human terms how the injuries have impacted your daily life, your work, and your family. And then it presents the math. It provides an itemized list of every single economic loss, from the ambulance bill to the projected loss of lifetime income, attaching every corresponding bill and expert report as an exhibit. Then it makes the argument for the non-economic damages, painting a vivid picture of your pain, your suffering, and your loss of enjoyment of life. Finally, at the very end, after pages and pages of building an ironclad case, it makes the demand, a specific total dollar amount that you are willing to accept to settle the case and release them from all future liability. This number is not pulled from thin air. It is the culmination of all that evidence, all that calculation, and all that legal strategy. This entire package, the letter and hundreds of pages of exhibits, is sent to the insurance company, landing on the desk of a specific person, the insurance adjuster. And you need to understand who this person is. The adjuster is not your friend. They are not a neutral party. They are a highly trained professional whose primary job responsibility is to protect the insurance company's money. Their goal is to pay out as little as possible on every claim, or ideally nothing at all. They are evaluated, promoted, and bonused based on how much money they save the company. So, when your demand package arrives, the adjuster begins their own process. They will scrutinize every detail, looking for any weakness. They'll question the necessity of a medical procedure. They'll argue that you were out of work longer than you needed to be. They'll claim your injuries aren't as severe as your doctors say they are. They will look for any reason at all, to devalue your claim. And then, after weeks, sometimes months of silence that can feel like an eternity, the phone will ring. It's the adjuster. They've reviewed your demand. They've seen your evidence. They've read your story. And they have an offer. And that first offer is almost always, without fail, an insult. It's a lowball number. A fraction of what your case is actually worth. It's not a good faith attempt to resolve the case. It's a test. They are testing your resolve. They are testing your patience. And they are testing your lawyer to see if they have the stomach for a real fight. And a good lawyer responds to that test with 2 words: file suit. This is the moment the entire process pivots. The informal back-and-forth negotiation with an insurance adjuster is over. We are now entering the formal, structured, and often intimidating world of the court system. When your lawyer calls you after receiving that insulting lowball offer, the conversation is no longer just about numbers. It's about strategy. They'll lay it out for you. They'll say, look, they've shown us they're not serious about a fair settlement right now. They're daring us to fight. So we're going to fight. This isn't a decision made lightly. Filing a lawsuit costs money and, more importantly, it takes time. It officially starts the clock on a much longer, more involved process. But it is the single most powerful tool. You have to force the insurance company to take your claim seriously. It moves the case from their turf, the adjuster's desk, to neutral ground, the courthouse. And it replaces the adjuster, whose job is to minimize payouts, with the defense attorney, whose job is to manage legal risk. It's a whole new ballgame. So, with your authorization, your lawyer gets to work on drafting the foundational document of your entire case. In most states, this is called the complaint. In others, like Texas, it might be called the petition. But the name doesn't matter as much as what it does. The complaint is your story, told in the formal language of the law. It's the document that officially starts the lawsuit. Think of it as the opening chapter of a book, laying out for the court and for the defendant exactly who you are, what happened to you, who you believe is responsible, and what you are asking the court to do about it. Let's break down what's actually in this critical document. It's not just a long, angry letter. It's a structured argument. First, it identifies the parties. That's you, the plaintiff, the one bringing the complaint, and the person or company you're suing, the defendant. It establishes the jurisdiction and venue, which is a fancy way of saying, here is why this specific court in this specific county has the power to hear this case. Usually, it's because the accident happened there or the defendant lives or does business there. Then comes the most important part, the factual allegations. This is a numbered list of simple, direct statements that lay out the facts of your case in chronological order. On June 1, 2023, plaintiff was driving their car northbound on Main Street. At the same time, defendant was driving their delivery truck southbound on Main Street. Defendant failed to stop at the red light and violently crashed into plaintiff's vehicle. Each sentence is a building block, creating a clear and undeniable picture of what occurred. Your lawyer will meticulously craft these sentences based on the police report, witness statements, photos, and your own account. After the facts, the complaint lists the causes of action. These are the specific legal theories for why you are entitled to compensation. The most common one in a personal injury case is negligence. The complaint will formally allege that the defendant had a duty to operate their vehicle safely, that they breached that duty, and that this breach directly caused your injuries and damages. There might be other causes of action too, like negligence per se, if they broke a traffic law, or if you're suing a company, maybe negligent hiring or supervision. Finally, the complaint ends with what's called the prayer for relief. This is where you formally ask the court for what you want. You literally pray that the court will grant you judgment against the defendant. You'll ask for compensation for all your damages, past and future medical bills, lost wages, pain and suffering, emotional distress, the whole list. In most jurisdictions, you don't state a specific dollar amount in the complaint itself. Instead, you'll ask for damages in an amount to be determined by a jury. Once this document is perfected, it's not just emailed over. It's formally filed with the clerk of court. Your lawyer pays a filing fee, and the clerk stamps the complaint, assigns it a case number, and officially opens a court file. Your lawsuit now exists. It's a public record. The clock is officially ticking. But the defendant doesn't magically know this has happened. The next step is one of the most crucial and honestly most dramatic parts of the process: service. The law requires that the defendant be personally notified that they are being sued. You can't just text them. Due process under the U.S. Constitution demands a formal, verifiable method. This is where a process server or a sheriff's deputy comes in. Their job is to take a copy of the complaint and a summons, which is an official notice from the court commanding the defendant to respond, and physically hand it to them. Imagine the scene. The defendant is at home, or at their corporate headquarters. A stranger walks up, asks if they are John Smith, and when they say yes, the stranger hands them a stack of papers and says the famous words, "You've been served." This is a profound moment. For the first time, the person who hurt you is confronted with the legal reality of their actions. There's no hiding. There's no ignoring it. The system has officially grabbed them by the collar. So what happens next? Panic usually. The defendant's first call is almost always to their insurance company. They forward the lawsuit papers, and the file lands on a new desk. It's no longer with the pre-litigation adjuster. Now it goes to the insurance company's legal department, or to an outside law firm that they keep on retainer. This is where the defense attorney enters the picture. This is the lawyer whose job it is to fight you and your lawyer at every single step of the litigation process. Their first order of business is to prevent a default judgment by filing a formal response to your complaint. That response is called the answer. The defendant's lawyer will go through your complaint, paragraph by paragraph, and respond to each of your factual allegations. For each numbered statement, they will either admit it, deny it, or state that they lack sufficient information to either admit or deny. They'll admit they were on the road that day. They'll deny they were negligent. They'll deny they caused your injuries. The answer is designed to be a blanket denial of all responsibility, but it does more than that. The answer will also list a series of affirmative defenses. These are legal arguments that basically say, even if everything the plaintiff says is true, we still shouldn't be held fully responsible. The most common one is comparative fault or contributory negligence. They'll claim that you were also partially at fault for the accident. Maybe you were going 1 mile over the speed limit, or you didn't brake fast enough. They are already planting the seeds to argue that if you are found to be, say, 10% at fault, your final award should be reduced by 10%. They will throw every possible affirmative defense at the wall to see what might stick later on. Once the answer is filed, the initial phase of the lawsuit, known as the pleadings, is complete. Your complaint has laid out your claims, and their answer has laid out their defenses. The battle lines have been drawn. The court now knows what the fundamental disagreements are. But right now it's all just words on paper. It's accusations and denials. The court has no way of knowing who is telling the truth. How do we get from a shouting match on paper to actual, usable evidence? How do we find out what their internal documents say? What their witnesses really know? How do we force them to lay their cards on the table? That's what comes next. The gloves come off, and the real war for information begins. This is the longest, most intensive, and often the most important phase of any lawsuit. It's where cases are truly won or lost, long before a jury ever hears a single word. It's called discovery. Discovery is the legal system's version of turning on all the lights and looking in every dark corner. It's a formal court-supervised process where both sides are legally required to hand over information relevant to the case. And when I say relevant, I mean anything that could potentially lead to the discovery of admissible evidence. It's an incredibly broad standard. This isn't about just finding the smoking gun. It's about finding the guy who sold the gunpowder, the person who made the bullet, and the map that shows where the gun is buried. The goal is to eliminate surprises at trial. In a perfect world, by the time a case gets to a jury, both sides know every fact, every document, and every witness's story inside and out. This war for information is fought with 4 primary weapons. Think of them as the 4 horsemen of discovery: interrogatories, requests for production of documents, requests for admission, and the big one, depositions. First up are interrogatories. These are the opening shots. They are written questions that one party sends to the other, which must be answered in writing under oath. This is crucial. Lying in your answers is perjury, a crime. These aren't casual questions. They are strategically crafted by lawyers to pin the other side down on the basic facts of the case. For the plaintiff, your lawyer might send interrogatories to the defendant asking things like, identify every person who witnessed the collision, state every fact that supports your claim that our client was at fault, or list every conversation you had about the incident in the 48 hours following it. For the defense, they'll be asking you similar things. List every medical provider you have seen in the last 10 years. Describe in detail the physical limitations you claim to have as a result of the incident. Identify every source of income you have had for the past 5 years. They are fishing for facts, names, dates, and a concrete version of the story that they can lock you into. Next comes the second horseman, requests for production of documents, or RFPs. If interrogatories are the questions, RFPs are the demand for proof. This is where the paper trail, and in the modern world, the digital trail, gets exposed. Each side requests the other to produce specific documents and tangible things for inspection. And the scope can be breathtaking. We're talking police reports, medical records, bills, photographs, videos, emails, text messages, phone logs, and employment records. In a car wreck case, your lawyer will request the defendant's cell phone records for the day of the crash to see if they were texting. They'll request the vehicle's maintenance history. They'll request photos the defendant took at the scene. Conversely, the defense will request every single medical record you've ever had, even from childhood, to see if they can find a pre-existing injury to blame your pain on. They'll ask for your tax returns to verify your lost wage claim. And here's where it gets really invasive. They will almost certainly request a complete download of your social media data. They want to see those photos of you on vacation smiling after you claimed you were in debilitating pain. They're looking for that one picture, that one post, that one comment that contradicts your claims. This is a huge part of modern discovery, and it's a minefield for plaintiffs who aren't careful. E-discovery, the process of handling all this electronic data, has become a multi-billion-dollar industry in itself because the sheer volume of information is staggering. The third horseman is a clever and often overlooked tool: requests for admission, or RFAs. These are not about discovering new information. They're about efficiency. RFAs are a series of simple, direct statements that the other party is required to either admit or deny. For example, admit that you were the driver of the 2022 Ford F-150 involved in the collision. Or admit that at the time of the collision, you were acting in the course and scope of your employment with XYZ Corporation. The goal is to get the undeniable facts out of the way. If the defendant admits a fact, it's considered proven for the rest of the case. You don't have to waste time or money proving it at trial. But if they deny something that is obviously true, they can be sanctioned by the court later on. It's a tool designed to narrow the battlefield and force the opponent to show their hand on what they're actually going to fight about. And that brings us to the fourth and most formidable horseman, the one you see in movies, the one that causes the most anxiety: depositions. A deposition is sworn testimony given outside of a courtroom. Picture this: you're in a conference room. On one side of a long table sits the opposing lawyer. Next to them might be their client, the defendant. On your side of the table is your lawyer. In the corner is a court reporter, with a stenography machine, typing down every single word that is said. You raise your right hand and swear an oath to tell the truth, the whole truth and nothing but the truth. And then, for the next several hours, the opposing lawyer gets to ask you anything they want that is remotely relevant to the case. There is no judge present to rule on objections. Your lawyer is there to protect you, but they can't answer for you. They can object to the form of a question if it's confusing or argumentative, but for the most part you have to answer. The deposition has two primary purposes for the other side. First, to find out what you know. They want to hear your story in your own words with all the details. They will ask you to describe the incident, your injuries, your medical treatment, and how your life has been affected over and over again from different angles. They are looking for inconsistencies. They are testing your memory. Second, and just as important, they want to see what you will be like as a witness at trial. Are you credible? Are you likable? Do you get angry easily? Do you get confused under pressure? Do you exaggerate? They are sizing you up for a jury. A plaintiff who comes across as honest, sympathetic, and consistent, even under a grueling multi-hour interrogation, is a defendant's nightmare. A plaintiff who gets caught in a lie, who is argumentative, or who can't keep their story straight can lose their case right there in that conference room. The transcript of your deposition, that document the court reporter is typing, can be used to impeach you at trial. If you say one thing in your deposition, and then try to say something different in front of the jury, the opposing lawyer will stand up and say, "But on May 15th in your deposition under oath, didn't you say this?" And then they will read your own words back to you. It's a devastatingly effective way to destroy a witness's credibility. This whole discovery process can take months, or in complex cases even years. It involves an endless stream of paperwork, letters, and emails back and forth between the law firms. There are constant fights. A lawyer might object to a discovery request, claiming it's overly broad, or seeks privileged information. These disputes often have to be resolved by a judge in what's called a motion to compel, where one side asks the court to force the other side to hand over the information. It's a painstaking, expensive, and often emotionally draining ordeal. But here is the single most important thing to understand about discovery. This is where the overwhelming majority of cases are resolved. 95% of personal injury cases never go to trial. They settle. And they settle because of what is uncovered during discovery. Once the depositions are done, once the medical records are exchanged, once the cell phone data has been analyzed, the true strengths and weaknesses of each side's case are no longer theoretical. They are laid bare on the table for everyone to see. The insurance company now knows exactly how you'll perform as a witness. Your lawyer now has proof of the other driver's negligence. Both sides can now make a much more accurate calculation of the risks and potential rewards of going to trial. The poker hands are revealed. And with that clarity, the real serious negotiations can finally begin. The information gathered in this war becomes the currency of settlement, paving the way for the next critical phase, moving the case toward either a resolution or the final countdown to the courthouse steps. With the battle plans drawn and the intelligence gathered, the lawsuit now enters its most pivotal stage. This is the moment of truth, the high-stakes negotiation where over 90% of personal injury cases find their conclusion, far from the polished wood and stern gaze of a jury. This is where the art of the deal truly comes into play, a delicate and often brutal dance between brinksmanship and compromise. It all begins with a document that carries the full weight of the discovery process, the formal settlement demand. This isn't the simple letter sent at the very beginning of the case. This is a comprehensive, multi-page legal thesis arguing your case. Your attorney will craft a narrative, a compelling story of what happened, backed by every piece of evidence unearthed. It will cite deposition testimony where the defendant admitted fault. It will include expert reports detailing the severity and permanence of your injuries. It will attach every medical bill, every pay stub showing lost income, and every receipt for out-of-pocket expenses. It's a meticulously constructed portfolio of your damages. But it's more than just a summary of facts. It's an argument. It lays out the legal theory of liability, citing case law and statutes that prove the other side is responsible. It then moves to the heart of the matter, the damages. It calculates the hard numbers, the medical bills, the lost wages, past and future, with precision. This is the easy part. The real art is in calculating and justifying the value of your human damages. The pain, the suffering, the emotional distress, the loss of enjoyment of life. Your lawyer will paint a vivid picture of your life before the incident and your life after, using your own deposition testimony, and a day-in-the-life video, and statements from family and friends to illustrate the profound, non-economic toll the injury has taken. Finally, at the end of this powerful document comes the number. The demand. This is the amount of money your attorney is asking for to settle the case in its entirety. This number is not pulled from thin air. It's a strategic calculation based on the strength of the evidence, the severity of the injuries, the amount of the medical bills, and, critically, what juries in your specific jurisdiction have awarded in similar cases. Sending this demand is like firing the opening salvo in the final battle. The ball is now in the insurance company's court. What follows is a tense waiting game. The insurance adjuster on the other side, now armed with the same depositions and documents your lawyer has, will analyze your demand package with a fine-toothed comb. They are looking for weaknesses, for inconsistencies, for any reason to justify paying less. Days or sometimes weeks will pass. Then the response comes. It will almost never be an acceptance of your demand. In most cases, it will be a counteroffer, and often it's a number that feels insulting. This is intentional. It's a negotiation tactic designed to test your resolve and dramatically lower your expectations. They are trying to see if you and your lawyer are serious about going to trial. This is where a seasoned attorney earns their keep. They won't be rattled. They understand the psychology of the negotiation. They will respond, not with anger, but with a reasoned counter-demand, methodically dismantling the insurance company's arguments and reasserting the strengths of your case. This back and forth can continue over several rounds of phone calls and letters. Each side inches closer, testing the other's limits, trying to find that middle ground where a resolution can be found. It's a high-stakes game of poker, where both sides are trying to gauge the strength of the other's hand and their willingness to go all in by proceeding to trial. But what happens when this back and forth hits a wall? When the parties are still tens of thousands or even millions of dollars apart? This is where the most powerful settlement tool in the legal arsenal is often deployed: mediation. Mediation is a formal settlement conference, a structured negotiation overseen by a neutral third party, called a mediator. The mediator is usually a retired judge or a highly experienced lawyer who has deep expertise in personal injury law. Their job is not to decide who is right or wrong, but to help both sides see the risks of trial and find a path to a mutually agreeable settlement. On the day of the mediation, you, your lawyer, the defense attorney, and a representative from the insurance company, the person with the actual authority to write the check, will gather, usually at the mediator's office. The day typically begins with an opening session. Everyone sits together in a conference room. Your lawyer will present a powerful, condensed version of your case, often using a PowerPoint with key evidence and photos. They are speaking directly to the insurance representative, making a final, compelling pitch for why your case is worth the money you're demanding. The defense attorney will then present their side, highlighting what they see as the weaknesses in your case and the risks you face if you go to a jury. After this opening session, the real work begins. The two sides retreat to separate private rooms, a process known as caucusing. The mediator will then spend the rest of the day shuttling back and forth between the two rooms. He becomes a shuttle diplomat, a confidant, and a devil's advocate all rolled into one. In your room, the mediator might listen sympathetically to your story, but they will also challenge you and your attorney. They'll ask tough questions. What if the jury doesn't believe your witness? What if the defense expert is very convincing? Are you prepared for the stress and uncertainty of a week-long trial? They are forcing you to confront the very real possibility that you could go to trial and lose, or win far less than you are demanding. Simultaneously, in the other room, the mediator is doing the exact same thing with the defense. They are pointing out the strengths of your case, the weaknesses of theirs. They'll say things like, "Your driver's deposition was a disaster. How will that play to a jury?" The plaintiff is incredibly sympathetic. A jury is going to love them. Are you really willing to risk a runaway verdict that could be double what you could settle for today? The mediator carries offers and counteroffers back and forth, but more importantly, they carry messages and insights. They help each side understand the other's perspective without the posturing and antagonism of direct negotiation. Hours can go by. It can be an emotionally draining and exhausting day, a roller coaster of hope and frustration. The numbers move slowly, sometimes painfully so. But as the day wears on, under the pressure and guidance of the mediator, the gap often begins to close. This is the ultimate fork in the road. By the end of the day, one of two things will happen. The first and most common outcome is a settlement. The mediator will find a number that both sides, while perhaps not thrilled with, can live with. A handshake deal is made. The terms are written down and signed. A wave of relief washes over you. The fight is over. The certainty of a settlement replaces the terrifying uncertainty of a trial. But sometimes, despite everyone's best efforts, the gap is just too wide. An impasse is reached. The defense won't offer a penny more, and you're not willing to accept a penny less. The mediation ends without a resolution. The handshake doesn't happen. You and your lawyer pack your briefcases and walk away, and the mood is entirely different. It's not relief, it's resolve. The time for talking is officially over. The last chance for a peaceful resolution has passed. The countdown to the courthouse, which had been paused, now resumes with a vengeance. The final battle lines are drawn, and all efforts now pivot to one single all-consuming goal: preparing to win at trial. This is the phase where the theoretical case, the one that has lived in files and on computer screens, must be transformed into a living, breathing story that can be told to a group of complete strangers. The focus sharpens from broad strategy to meticulous, granular detail. Every piece of evidence, every potential witness, every line of questioning is now viewed through a single lens. How will this play in front of a jury? The first and most critical step is preparing the witnesses. And the most important witness by far is you, the plaintiff. Your attorney will now become your director, your coach, and your toughest critic. You'll be put through a process that can feel like a grueling series of rehearsals for the most important performance of your life. This isn't about memorizing a script. In fact, that's the worst thing you can do. It's about preparing you to tell your own truth, clearly and compellingly, under the immense pressure of a courtroom. You'll sit in a conference room for hours, going over your deposition testimony with a fine-tooth comb. Your lawyer will play the part of the opposing counsel, firing questions at you. Some will be straightforward. Others will be tricky, designed to confuse you, to make you angry, to trip you up and force a contradiction. They'll ask the same question 5 different ways. They'll twist your words. They'll challenge your memory, your motives, your character. It's an uncomfortable, often exhausting process, but it is absolutely vital. The goal is to desensitize you to the tactics of cross-examination, so when it happens for real, you're not rattled. You learn the golden rules of testimony. Listen to the entire question. Pause before you answer. If you don't know, say you don't know. If you don't remember, say you don't remember. Never guess. Never argue. Just answer the question asked and only the question asked. The same intense preparation is done with other key witnesses. Your spouse might be prepped on how to describe the changes they've seen in you since the injury. Your doctor will be walked through the medical records, ensuring they can explain complex medical concepts in a way a jury can understand. Your expert witnesses, the accident reconstructionist, the economist, will have their reports and conclusions stress-tested, anticipating every possible line of attack from the other side. Each witness is a single instrument, and your lawyer is the conductor, ensuring everyone is in tune and ready to play their part in the symphony of your case. Simultaneously, the legal team is engaged in a massive logistical undertaking, marshalling the evidence. This is where the story of your case gets its props. Every photograph of the accident scene, every medical bill, every X-ray and MRI film is organized, marked, and prepared as a potential trial exhibit. The team creates what are called demonstrative aids, large-scale visual tools designed to help the jury understand key points. This could be a huge, blown-up diagram of the intersection where the crash occurred. It might be a 3D animation showing the mechanics of your surgical procedure. Or it could be a simple, powerful chart illustrating your lost wages month by month. In the age of short attention spans, showing is always more powerful than telling. And these exhibits are designed to make your story tangible and unforgettable. As the trial date looms, another critical event takes place: the final pretrial conference. This is a meeting with the judge and the opposing counsel, held in the judge's chambers or in the courtroom itself. It's the final housekeeping session before the main event. Here, the lawyers will present the judge with their final witness lists and exhibit lists. They'll agree on a set of undisputed facts to streamline the trial. And most importantly, they will argue what are known as motions in limine. Think of these motions as a strategic pretrial battle to define the battlefield itself. In limine is Latin for at the threshold. These are requests made to the judge to exclude certain evidence or testimony from the trial before the jury even hears it. For example, your attorney might file a motion to prevent the defense from mentioning that you had a minor traffic ticket 5 years ago, arguing it's irrelevant to the current case, and would only serve to prejudice the jury against you. The defense, in turn, might file a motion to exclude a particularly graphic photograph of your injury, arguing its emotional impact would outweigh its informational value. Each side is trying to hamstring the other, to take away their best arguments or their most damaging pieces of evidence before the curtain even rises. The judge will listen to the arguments and make rulings. Motion granted means the evidence is out. Motion denied means it's in. These rulings can dramatically alter the landscape of the trial, forcing lawyers to pivot their strategies at the last minute. With the rules of engagement set, the final and perhaps most mysterious piece of the puzzle falls into place: selecting the jury. This process, known as voir dire, is a French term meaning to speak the truth. It is one of the most crucial and least understood parts of any trial. The process begins with a large group of ordinary citizens, the jury pool, being summoned to the courthouse. They file into the courtroom and the judge gives them a brief overview of the case, what it's about, who the parties are, and how long it's expected to last. Then, the lawyers get their chance to question them. This is not, as many people think, about picking the jurors you want. It's about getting rid of the jurors you don't want. The lawyers are searching for bias, spoken or unspoken. They are looking for life experiences, attitudes, and preconceived notions that might make a potential juror unable to be fair and impartial. The questions can feel deeply personal. Have any of you ever been in a serious car accident? Do any of you have strong feelings, one way or the other, about people who file personal injury lawsuits? Has anyone here had a negative experience with a doctor or a hospital? Do you believe there should be caps on how much money a jury can award for pain and suffering? The lawyers are watching everything. Not just the answers but the body language, the hesitation before answering, the slight eye roll, the folded arms. They are trying to read a room full of strangers and predict how they will react to the story they are about to tell. If a potential juror says something that clearly shows they cannot be impartial, for example, "I think all lawsuits are frivolous," a lawyer can ask the judge to dismiss them for cause. There's no limit to how many jurors can be dismissed for cause. But the real art comes with the other tool lawyers have: the peremptory challenge. Each side gets a limited number of these strikes, and they can use them to dismiss a juror for almost any reason at all or no reason. Maybe the lawyer just gets a bad feeling from someone. Maybe a juror's profession as an insurance adjuster makes the plaintiff's lawyer nervous. Maybe another juror's bumper sticker, which the lawyer's investigator spotted in the parking lot, suggests a worldview that won't be sympathetic to the case. It's a high-stakes game of psychology and intuition. Slowly, methodically, juror by juror, the pool is whittled down until only the final panel remains, typically 6 to 12 people plus a few alternates. These are the people who will hold your future in their hands. They are the audience for whom this entire multi-year production has been prepared. Once that jury is sworn in, a profound silence seems to fall over the courtroom. The what-ifs and maybes are over. The strategic maneuvering is done. The audience is seated. Your lawyer gives you a final reassuring nod. The judge turns to your attorney and says the words that signal the beginning of the end. "Counsel, you may begin your opening statement." The trial has begun. The air in the courtroom is thick with anticipation. This is the moment where the story of your case is told for the first time. Not as a collection of legal documents, but as a human drama. Your lawyer's opening statement is a promise to the jury. It's a roadmap of the journey they are about to take. They'll outline the facts, introduce the key players, and state with unwavering confidence what the evidence will prove: that the defendant was negligent, and that their negligence caused your injuries. They paint a picture of your life before the incident, and the life you've been forced to live since. Then the defense attorney stands. Their job is to offer a different story, an alternate reality. They might suggest the incident was an unavoidable accident, that your injuries aren't as severe as you claim, or even that you were partially to blame. They are planting the first seeds of doubt. With the stage set, your lawyer calls their first witness. This begins your case in chief. And that first witness is you. As you walk to the witness stand, every eye is on you. You swear an oath to tell the truth. Your lawyer begins what's called direct examination. The questions are open-ended. Where were you going on that day? What happened next? How did that feel? The goal is for you to tell your story in your own words. To connect with the jury not as a plaintiff but as a person. You recount the moments leading up to the incident, the shock of the impact, the pain, the confusion, the long road of recovery. You are the main character in this story, and this is your testimony. Then comes the part everyone dreads. Cross-examination. The defense attorney approaches. The tone shifts. The questions are no longer open-ended. They are sharp, pointed, and leading. Isn't it true that you didn't see the doctor for 3 days? You've had back pain before this incident, correct? Their goal is to control the narrative, to poke holes in your story, to challenge your memory, and to minimize your suffering. Your lawyer has prepared you for this. The key is to remain calm, to be honest, and to answer only the question that is asked. It's a grueling, stressful experience, but it's a necessary test of your case's strength. After you testify, your lawyer builds the case around you brick by brick. They call an eyewitness who saw the whole thing happen, corroborating your version of events. They call your doctor to the stand. The doctor explains your medical charts, the x-rays, the diagnoses, and gives a professional opinion on the long-term impact of your injuries. This isn't just your word anymore. It's a medical fact. They might even call an economist, who presents a cold, hard calculation of your past and future lost wages, your medical bills, and the cost of future care. Each witness adds a layer of proof, transforming your personal story into a mountain of evidence. With each witness, the defense gets their chance to cross-examine, to challenge, to create doubt. Once your lawyer has presented all their evidence and witnesses, they stand and say the words, "The plaintiff rests. The torch is passed." Now, it's the defense's turn to present their case in chief. They will call their own witnesses. It might be their client, the defendant, who tells their version of the story. They might call an expert witness of their own. A doctor who reviewed your records and believes your injuries are not as permanent as your doctor claims, or an accident reconstructionist who argues the crash happened differently. It's a direct clash of narratives, a battle of experts, and the jury is caught in the middle, trying to decide which version of reality is more likely to be true. When both sides have rested their cases, the final act begins, the closing arguments. This is not about presenting new evidence. It's about storytelling. It's the lawyer's last chance to speak directly to the jury and persuade them. Your attorney goes first. They walk the jury back through the entire trial, connecting the dots. They'll pick up the theme from their opening statement and show how every piece of testimony, every document, every expert opinion has fulfilled that initial promise. They'll highlight the defense's inconsistencies. They will speak of justice, of responsibility, of making you whole again. It's an appeal not just to logic, but to the jury's sense of fairness and empathy. Then the defense attorney delivers their closing. They'll argue that the plaintiff has failed to meet their burden of proof. They'll re-emphasize their own themes, highlighting any testimony that created doubt. They'll minimize the damages and argue that their client did nothing wrong, or that the plaintiff's claims are exaggerated. They are making a final appeal to reason and perhaps to skepticism. After the echoes of the closing arguments fade, the judge turns to the jury. This is a critical, often overlooked step. The judge reads the jury instructions. This is the law. The judge explains the legal standards the jury must apply to the facts. They'll define negligence. They'll explain the concept of preponderance of the evidence. Unlike a criminal case where the standard is beyond a reasonable doubt, in a civil case like yours, the standard is much lower. You only need to prove that your version of events is more likely true than not, even if it's just 51% to 49%. The scales of justice only need to tip ever so slightly in your favor. Then, the jury is led out of the courtroom to a private room to deliberate. The door closes, and for you, your lawyer, and the defendant, there is nothing left to do but wait. This is the most agonizing part of the entire process. In that room, 12 strangers will choose a foreperson, review the evidence, argue, debate, and try to reach a unanimous decision. They will decide who is at fault. They will decide what your pain, your suffering, and your loss is worth in dollars and cents. Could take hours. Could take days. Finally, the call comes. The jury has reached a verdict. Everyone reassembles in the courtroom. The air is electric with tension. The jurors file back into the jury box, their faces unreadable. The foreperson hands a slip of paper to the bailiff, who gives it to the judge. The judge reads it silently. Then the verdict is read aloud. In that single moment, months or even years of struggle, pain, and uncertainty come to a head. A finding for the plaintiff, followed by the amount of damages awarded, or a finding for the defendant. It's a moment of profound relief and vindication, or one of crushing disappointment. But even after the verdict, the fight may not be over. The losing side can file post-trial motions, asking the judge to overturn the jury's verdict. And if that fails, they can appeal the case to a higher court, arguing that a legal error was made during the trial. The appeals process can add years to the timeline. This entire journey, from the moment of your injury to the final verdict and beyond, is a marathon. It's a test of endurance, faith, and resilience. It is a complex, often frustrating, and deeply human process. But it is also the foundation of our civil justice system. It is the mechanism we have designed to hold people accountable, to provide a voice for the injured, and to turn the chaos of a traumatic event into a quest for fairness and resolution. It is the long, hard road to justice,